Thank you. Workers' compensation is kind of an interesting development, and it really started in Europe when the Europeans went through the Industrial Revolution and they got rid of all the workers that were working in the agrarian community. What had happened is in Europe, the vast majority of the workers were working agrarian type of employment, and when they had a job-related injury, they were working for families, and these agrarian families would take care of the workers. Well, as the corporate structure started to develop and the agrarian employment opportunities dissipated, Europe recognized that these workers that were injured in an industrial complex were not being able to get medical care, they were not getting benefits. So the Europeans initiated this concept of workers' compensation, that if you have a job-related injury, you're going to be protected. This started to move to United States, and it got to the United States in the early 1900s. And again, the concept was that the workers, when they were injured in the work situation, if they're not working for a family that loves and cares for them, they were being discarded. So they started to develop the concept of workers' compensation, and it evolved. In about the 1930s, our society recognized that there's a segment of our population that's different than the other labor market. And they recognize that safety workers engage in different types of employment, and the exposures that they have are different than other types of workers. So they started creating some special legislation called the presumptions. And the presumptions, you still had to show that there was a connection to the employment, but the threshold was not quite as high. And this evolved. There are two types of injuries, whether you're a federal employee or a state employee. There's two types of injuries. And one injury is a specific injury. I'm overhauling, I injure my back. I'm pulling a charge line, I trip, and I injure myself. That is a specific injury. The other type of injury is called a cumulative trauma or continuous injury. Both the federal and the state system acknowledges that type of injury. And the cumulative trauma is akin to like you bend a paper clip, you bend it, eventually breaks. So let's say I'm doing wildland suppression, and I come into a canyon where the neighborhood, the populace have put cars, trash, you name it, and I have not just exposure to plants, but I have exposures to tractors, tires, paint, solvents, and I have those exposures. The concept of the cumulative trauma is it's not one event, but it's everything combined over a period of time, and it's different. If I'm wearing a breathing apparatus, if I'm pulling charged lines, if I'm going up and down inclines, that work is entirely different than anything I do domestically. Domestically, how often do I wear the breathing apparatus? How often do I overhaul? How often do I pull charged lines? I don't. In my domestic life, it's sedentary. In my domestic life, if I'm symptomatic and my back's bothering me, I have the option of not engaging. But if I'm in the field and we have something we have to do and my back's bothering me, and if I don't engage in that activity, it's going to risk the public, other safety people, I will continue. So the idea of the cumulative trauma has been embraced. And the idea is it's a multiplicity of things that occur, and it's different than anything you do domestically. Now, for the safety group, there's a heart presumption, there's a cancer presumption, there's a hernia presumption, and interestingly, the cancer presumption that was initially created in California for state, city, county, the cancer presumption had no value. No value because the threshold to show that it was job-related was so high. I had a firefighter come to me, he had prostate cancer, and he said, can we do something? So I looked at the legislation. I said, yeah, I think we can. So we litigated the case, and the case that I'm talking about is Walter Faust versus the City of San Diego. It's a published case, and I'm not sharing any attorney-client privilege. You can look it up. So we litigated the case, and the judge laughed at me. He said, you're never going to prevail. That's a prostate cancer case. You're never going to prevail. I said, Your Honor, what I need to do is show the exposure to carcinogens. That's what I need to do. Then it's upon the employer to rebut that. No, you're not going to do it. You're not going to do it. And all the case law up to that point in time had supported what the judge said. So I had Walter get on, and he talked about wildland suppression that he had done. He talked about going to auto fires. He talked about wearing a BA, sometimes not wearing a breathing apparatus. And he went into this multiplicity of exposures. We talked about filling up the rig. Sometimes the diesel would get on his hands. We talk about, at that time, the rig would pull inside the area that they leave, and they did not have exhaust hose. And the remnants of the exhaust was still there. And we litigated, and the court came back and stated that presumption prevails because I demonstrated the carcinogens. Now, when it comes to the presumptions, you still have to show that there's factors of employment. And this is where it becomes rather tricky for the cardiovascular. If I were to ask anyone in this group, do you like your work? Do you like your work? Do you like, oh, I love my work, Scott. I love my work. I love my work. That in itself is what the defendant, the city, the state, the county would like to hear. Then I would ask him, I said, do you know what a crispy critter is? Yeah. Have you ever seen a crispy critter? Yeah. Have you ever gone to the garage and seen grandma with a sack over her head? Yeah. Have you ever gone to the garage and dad's hung himself? Yeah. Have you ever come up to a motorcycle incident where the Marine got back from deployments, driving the motorcycle and gets decapitated? Yeah. Do you like that? No. Is that stressful? Oh. And we start talking about that, and we talk about how to articulate the reality of the employment. So when that inquiry is made, you don't put Mr. Sunshine on, but you're talking about the reality. But even with that, there's a tendency to not want to talk about that. So I'll discuss with the client, they're working what's going on. I say, where'd you go to high school? What year did you graduate? What was your favorite car? And they tell me, I said, do you like your work? Oh, yeah. And I'll go through the scenario, the other exposures they have. And I'm not trying to tell them what to say. I'm trying to educate them so when that inquiry is made, the information they give is not just spontaneous, it's spontaneous with substance. They've weighed and measured everything that's occurring. Because in this process, whether it's a federal, state, city, county, the investigative process is to go back and see if there's substantial evidence that supports that. And the substantial evidence is the comments that are made to the treater, the comments made to your fellow workers. So once the person has this concept in mind, when that inquiry is made, they've weighed, they've measured, and they speak to the reality. That's the substantial evidence. And the substantial evidence has to be there to support the relationship to the employment. Why would I want to do workers' compensation? It's a mess. Why would I want to get involved in the workers' compensation? Well, it goes back to protecting yourself and protecting your family. And many years ago, I had a motor officer that I represented, and he was involved in an accident. At that time, it was lucky. It was a small knee injury, had surgery, developed phlebitis, post-phlebitis, had stroke, and has required 24-hour care for probably 18, 19 years. The health plan he had would have covered it for 90 days. They would have covered it for 90 days, and after that, they would not be responsible. So I litigated the case, and his spouse gets paid $15 a day to help him. $15 an hour, 10 hours a day to help him because of this. I had the house revamped. The employer paid for it. I had a van bought for him. And what it is the medical care under the California system is to cure or relieve the effects of the injury. And these were part of the effects of the injury. The inability to get up and go, the continence problems he was having, and that connected. So why would you want to file a workers' compensation? Because the expansion of the benefits is beyond anything else that you get under any other type of health plan. Is it a pain? Yeah, it's a pain. Is it irritant? It is. So what I have, we talked about the types of injuries, the specific injury. I pull a charged lion, I walk over spaghetti, I fall down, I injure myself. I'm lifting a two-man ladder by myself, I injure myself. That's a specific injury. The cumulative trauma, again, is like bending the paper clip. You bend it, So those are the type of 2 injuries that both the state, county, city, and Fed systems acknowledge exist. But it goes back to the articulation, the expression as to what you're doing and what's going on. And the next one is the presumptions. I talked to you about some of the presumptions, and the presumptions makes the threshold somewhat easier, but you still have to prove up. You have to prove up. So if I have hypertension and I have LVH, left ventricular hypertrophy, or left atrium enlargement, if I have that, then I can get the benefit of the presumption on the heart shifted over to my hypertension, because the hypertension has caused end organ damage, And that's something that the employer is not going to run up and jump and provide that to you, but that can occur. I take medication for my orthopedic problem. I have an orthopedic problem, and my medication causes diarrhea, constipation, blood and stool, esophageal reflux, GERD. In that situation, if the medicine that I'm taking changes another function, the medication I'm taking for my jar-blood injury, if it changes another function, then that becomes the responsibility of workers' compensation. And medication for hypertension, one of the common things causes a dryness of mouth, and that can cause dental problems. That becomes a responsibility. And that's his expansion. That's the expansion of workers' compensation. Now, in workers' compensation, there is what's called a cap. And the cap is the amount of money that you can receive. In the civil litigation that we do, there's no cap. The sky is the limit. We can go up here. But part of the bargain that was entered into, by the employees with the employer is we don't need to show fault. We just need to show there's a connectivity. And once we show connectivity, we get medical care to cure and relieve the effects of the injury. So that's the value. Now, that connectivity is something that they're going to fight. And that goes back to how you articulate, how you express what you're doing in your work situation. Now, medical care, medical benefits, expansive. There were some changes done. And one of the changes, the last change that was done is in 2012. And this is how it was marketed. They got a group of labor people together late one night, and they said, you know, the problem is with this medical care, where the employer disputes it, that poor worker has got to go in front of a judge and testify, and then that poor judge has got to look at the medical evidence, and it takes such a long time. So here's what we're going to do. The employer already has the medical provider network list that they were allowed to create. Medical provider network list means the employer can go out and select who the doctors are if you have a job-related injury, if you don't predesignate. So that existed. The utilization review concept also was embraced, and the utilization review allows the employer, I'm the employer, and I can go out and hire you as a group of doctors, and I have the doctor's report, and the doctor has seen this patient 25 times, and he opines, we need more PT, we need to do some injections, we need to do this. Then I would take that report from that treating doctor, and then I walk it over here. Here, utilization review doctor, take this, and then study that, and then you tell me whether that's medically appropriate. Well, again, the utilization review doctors, they have a contract with the employer. They never see the patient. And if that doctor comes back and states, you don't get the medical care, then the worker's out because of a doctor that never has seen them. So until this change was made, what we would do, we'd go in front of a judge, and I would have the judge say, Your Honor, my patient, the client, the patient, has seen this doctor 18 times, and this is the recommendation. The utilization review doctor has never seen him. And probably 95 to 98% of the times the judge say, what in the hell are you here for? I'm going to go along with the treating doctor. And they would grant the care. Well, this meeting they had in 2012, they said, what we're going to do, unions, what we're going to do, employees, we're going to take that utilization review and expedite it. You won't have to go in front of a judge. We're going to use IMR doctors, independent medical review doctors. And these magic doctors work for the state, supposedly. Oh, by the way, you're never allowed to know who the doctor is. You're never allowed to know who that doctor is. Oh, by the way, that doctor will never see the patient. If the independent medical review doctor comes back and supports the denial of medical care, and they do about 93, 94% denial, if they deny it, then the worker does not have a right to go in front of a judge unless they can show fraud. Well, you can't show fraud because you don't know who the doctor is, IMR. So the IMR process goes on, and some of the real sad stories where people are really harmed by this, I have one right now, a CHP 82-year-old officer, and represented him for many, many years, gets the medical care, gets the same medical care, and the employer sends a utilization review. They deny the medical care this guy's had for years. Now he goes to IMR, and the IMR doctor has come back and said, you don't need this medical care. You don't need this medical care. So he calls me up and tells me what is going on. So we go through the process, and what I'm able to do, a little gamesmanship, I have my client go back to the treating doctor, and the treating doctor has an opportunity to unilaterally call and speak to the utilization review doctor. He got one-on-one conversation with the utilization review doctor, and they connected as humans, so the utilization review doctor overturned. Well, the majority of the cases, you have people in their 80s, their 70s, whatever it may be, they're not going to be able to access that. What the employer is going to do is say, Mr. O'Mara, you have been receiving medical care and it's now been denied. We have a magic answer for you. We're going to offer you this compromise and release. And the compromise and release is we will pay you $35,000 for your medical care. Here's your $35,000. And you'll give up the medical care, and you don't need to. You don't need to go through this process. Well, the worker, in many times, cannot find an attorney to represent them because the way it's set up, the attorneys are not in a position to get compensated unless there's a compromise and release. If there's a compromise and release, they can charge an attorney fee on that. And unfortunately, some attorneys get blinded by that and embrace that concept. So if that occurs, if the worker sells their medical rights, gives that up, let's think about the health plan. Let's say that I have a health plan, and I go from a job-related injury that was to be the responsibility of the employer because of my job-related condition. I sell out my medical, and now I need to get medical, and I go back to my health plan. It's shifting the cost from the employer to the individual health plan, and that gradually increases. So what I have done, I have attached some legislation that I have drafted, and the legislation goes back and creates an equality, And the concept is this: if I am treating with the employer's medical provider network, and if that doctor opines that I have need for medical care, my case is not subject to utilization review. It's not. They have to grant the medical care. Well, the employers are not going to be wild about this, but that's there. But I've also put a provision in, if a worker wants to utilize utilization review, they can do that. They can do that process. If they want to use independent medical review, they can do that, but they have to agree to that. And the concept is, the California Constitution specifically states, if I have a job-related injury, I'm entitled to medical care to cure and relieve the effects of the injury. And this new change that they did in 2012 that still is here today is really harming the workers. And the really sad part is the workers are getting harmed more are the people that are elderly, because they don't have an opportunity, they don't have the knowledge as to what's going on, and now this flash money is being hung out there for them. So when you look at the proposed labor code changes that I'm looking at, again, it's not going to put money in the attorney's office, not going to put money in the attorney's pocket. It's going to take care of the injured worker. From an employer perspective, what it does, it puts things on an equal playing field, and from the employer perspective, they're better off to not have this passed because they're going to be able to get responsible for the medical care to cure and relieve. Any questions so far what I'm talking about? Okay, now, when you see your doctor, this goes both for state, county, city, and federal. When you see your doctor, you need to have rapport with your doctor. You think about you as a group of firefighters, people that work wildland, anything like that, you have a personality. If you go into that office and, hi, how are you, receptionist? Oh, I'm glad to see you. My name's Scott O'Mara. You develop rapport. You develop rapport with the PA or the nurse. You develop rapport with the doctor. Consciously or subconsciously, you're going to impact how they respond to you and the need for medical care. If they see you as a human being and they recognize that you're a human being, when it comes time to take those extra steps, they're going to do that either consciously or subconsciously because they see you as a human being. And I will go through that with the client again and again and again, how important that is. If you cook cookies at home, take 5 or 6 cookies in there to the office. That sounds stupid. It really sounds stupid. But I'm telling you that rapport is so powerful, so powerful. When I call the doctor and I want the doctor to provide a supplemental report they're not going to get paid for, and if my client has done those extra steps, I get it. I get it. I get those extra steps. And it doesn't put money in my pocket. It gives them medical care to the worker. Now, the next game is played. Everyone in this room knows what subjective complaints are. Subjective complaints are my perceptions as to what discomfort I have. Objective findings would be the MRI, herniated disc, L4, L5. Objective findings may be the EKG, echo. What they will do, the adjuster, and this is part of their training, it's not that they're bad or evil, but they will look at the subjective complaints. And if they think the subjective complaints are out of place with what reality is, that's going to start them to vet the case out more. So what I would do is I'll talk to the client. What I want you to do, let's say you've had 2 weeks of pain, you have incontinence problems, you can't get up and move, you can't do yard work, you can't play with your grandkids, you can't walk the dog. I want you to give a more full picture, When you talk to your doctor about the pain and discomfort, I want you to recognize you have good days and you have bad days. You have good days and you have bad days. If you reflect that comment to the doctor, my subjective complaints, I do have some pain and discomfort, but I do have good days and bad days, then that then eviscerates or takes away from the adjuster getting focused on that case because I'm acknowledging I have good days and bad days as opposed to, oh God, I can't take the trash out. I can't do my yard work. I can't play with my kids. I can't play with my grandkids. Well, maybe I couldn't during the past 2 weeks, but overall. So I will talk to the client. I'll say, now, what we're talking about here, reflecting the subjective complaints in that light may take some money out of your pocket, but that's not the reality. The reality is, do you have good days and bad days? And if you reflect that, then that reality causes that adjuster to go over and focus on somebody else's case. And that relationship, that documentation is also paramount to another concept. And the other concept is, for many employees in many groups, if you have a job-related injury, and if the job-related injury precludes you from doing your substantial duties, and the employer cannot accommodate you, will not accommodate you, then that puts you in a position for an industrial disability retirement. An industrial disability retirement goes back to the concept of the occupations that you have. The education experiences you have is very narrow when it comes to the labor market, very narrow when it comes to the labor market. So if I have a job-related injury that impacts my ability to lift, carry, push, pull, sit for prolonged periods of time, that means that my ability to go out and get a job with my education experience is narrow. So the federal government, not the state, not the city, not the county, not the fire district, but the federal government has come back and stated, if you have a job-related injury, and that job-related injury precludes you from doing your substantial duties, and that findings made per either CalPERS or SERS, or in case of City of San Diego retirement, if that decision is made, the first 50% of your income is not subject to taxation. So let's say I could retire right now at 95%, 95%. And if I had a job-related injury that precluded me from doing my substantial duties, that first 50% is not subject to taxation. And it's not that they're putting a bonus, they're recognizing that your education, your experience is very narrow. So as you move along towards your retirement dates, as you get closer to your retirement dates, you need to be candid with yourself. On a bad day, can you go out and do your work? On a bad day, could you do wildland suppression? Could you crawl down in the canyon? Could you come back up? Could you use a gurney carry, chair carry, stair carry? Could you do those things on a bad day? And if you decide that you cannot do that on a bad day, then that's opening up the door for disability retirement. And you're not trying to rip anybody off. It goes back to what the feds did. And the feds have acknowledged that because of the training experience you have, it's very narrow. And then they're trying to protect you so you have a decent opportunity. If you acknowledge that, and that process occurs prior to you leaving the department, if that occurs prior to it, then you can come back and get the disability retirement. I have clients that will retire and then will come back 3 years from now, 3 years after retirement, and say, you know, Scott, I've been thinking about it, and I couldn't do it, I couldn't do it. Well, they've missed that window, they've missed that window. So you need to think about that. So retirement is another benefit, and the benefit is you are the giving person that's made a difference in protecting our society. And society is trying to acknowledge that by protecting you and your family and your other opportunities. The next thing is, in the workers' compensation system, right now, they're not acknowledging what I call post-traumatic stress and PTSI. And there's a change that's being made, and it's the blue sheet right here. And this came back in February. It's 542. And you look at the language in here, and you look what the writers are talking about, and they really have a sense as to the horrific events that you see. They really acknowledge that. And they're trying to say the threshold of showing that it's job-related does not need to be quite as high. I had a case I recently did. I can't say what organization, but this person worked for an organization, and he started self-medicating. And the self-medication was alcohol. And he took more alcohol, more alcohol, more alcohol. And he's talking to his wife, and his wife made a small remark, nothing terrible, and he overresponds. He overresponds. And they get involved in a physical confrontation, and the children panic. They go to the neighbors. The SO comes over. They take him out, and he eventually acknowledges this occurred, and the government came back and said, DV, the employer terminates him. So he comes to me, and I said, okay, tell me about what you're doing. He talks about, he saw a rollover many years ago, and the bus had many, many passengers in it, and it rolled over and 10 people were killed. He comes up to see that, and there's levels of decapitation, arm lost this and that picture's in his mind. And then 2 days after that event, he's on the same road, and there's a rollover car, and 2 people are again killed. And then he continues with his career, and he sees this event, this event, this event, and he's not willing to go out and get medical care or assistance because he's a tough guy. He's a tough guy. I don't want anyone to know that. So his career goes on. He starts self-medicating, and the alcohol becomes more and more prevalent. So he describes this to me. And I think, okay, let me see what I can do. So I take the case on, and I get in front of the doctor, and the client was able to go into really graphic details, which I'm not going to share with you, as to what he saw, the smells, everything. And the doctor knew that. The doctor came back and said he had post-traumatic stress disorder. The employer came in and said, no, he's an alcoholic. He's an alcoholic. And I mean, they fought us. They fought like hell not to give this. They didn't want to raise a new standard. It's not a new standard. So they fought like hell. We litigated the case, and we prevailed. So I got him an industrial disability retirement. Plus, I now have lifetime medical where he can go out and see the psychologist, psychiatrist. It goes back to the threshold. And what he's talking about in this bill, what he's talking about is acknowledging the unique exposures that you have. When I first started this many years ago, a couple clients came in flyer and they said, you know what a crispy critter is? No. So they described that to me. You ever cooked a steak? I said, yeah. And they described the smell of that and other things. And as they start giving me that information, I started having a grasp, not an understanding, a grasp as to what's going on. And they would talk about how their work is different than anyone else. We talk about Iraq, Afghanistan, and if I was deployed there, I'd be physically removed from where I lived. And when I came back, I'd be physically removed. And they're talking about areas that they drive by, places they go, and causes this reflection as to what they've seen. And this bill, he acknowledges that. He acknowledges the uniqueness of what you do. And I think it's a very, very powerful bill, and I think it's based upon reality. It's based upon reality. And I anticipate that the employers are going to want to fight it because it's going to increase their responsibility. So for you, as you look at the bill, and if you agree with it, you may want to give some thought. You may want to give some thought to support that because the impact is not just the worker, but the whole familiar family situation. Okay? So the other thing, and this is kind of unique, is our governor did his state of address in February 9, 2019. And he was talking about the different things that I know fire sees, even wildland fire sees. And that is people that are having issues with life. They're living under a tent. They may have drug addiction. They may have some type of blood transmittable disease to you. And he's acknowledging how that's become more prevalent, more prevalent, more prevalent. Unfortunately, it is. Unfortunately, it is. And there is special legislation on bloodborne pathogens, that if I develop that problem, I am covered because of the presumption. They have a timeline on the presumption. And the timeline can be anywhere from 5 years or 10 years. Cancer has been extended to 10 years. The 10-year presumption does not really mean the reality of what occurs. I have a case right now we completed, and this person is 19 years out of employment. 19 years, I tried and I litigated, I prevailed. All I need to show is that the manifestation or development, the manifestation of the development of the cancer was within that presumptive period. So in this particular case, it was a kidney-type cancer, and the flank problem, the discomfort that the individual had, was manifesting itself and developing during this presumptive period of time. The actual diagnosis did not occur until many years later. I was able to go back, and that is because our client had a good relationship with the doctor, and when they shared the subjective complaints, I was able to go back and identify those and use that to show that the 10-year limitation was not one that is mandated. And that again goes back to what I said before, the relationships that you have with the doctors. So important. And that evidence that's there is given of great value because that evidence is established before you have an attorney. That evidence is established before you even have a diagnosis. Now, there's a section of the Labor Code, 5412, and it describes date of injury. Date of injury is when you knew or should have known the condition is job-related. And the employer, even if the condition is job-related, they will raise the statute of limitation if they can to bar you. They will bar you. So if you think that you have a condition that's job-related, you need to talk to an attorney and get some idea. If the attorney tells you it's job-related, you have 1 year from that time to file. If the doctor tells you it's job-related, you have 1 year from that time to file. Even though it's outside the 5-year window for heart, even though it's outside the 10-year window, if the doctor shares with you that it's job-related, and that's the first time that you became aware of it, then that is where the statute begins. So for you, I'm a firefighter. I care for people. I'm compassionate. That's why I'm doing it. And I'm sure that risk management is going to be caring and compassionate with me because I'm out here trying to help people, and they're very polite to me over the phone. They're very nice to me, and I don't want to mess around. I just want to get my benefits. Okay. The training experience, and I'm not saying the adjusters are bad people, but the training experience that they have is to contain and control and minimize. So for you, If somebody wants to come and take your statement, I want to take your statement about the exposure that you had. I want to take a statement as to what your condition is. If someone thinks the case is so important that they want to take your statement, you need to get some counsel. You need to get some idea so you understand. No, they're good people. I'm a good person. They're not going to try and manipulate me. I worked for this employer for 25 years. I love the people. I know the city manager. I know the mayor now. No. So for you, you need to be realistic because you're not just looking at yourself, but you're looking at your family. You don't want to be an economic burden to your family, to your kids, your grandkids, because of your medical problems that could be covered. So the workers' compensation is unique. It's different. I'll start winding up. Sorry. I get on the talking mode. Let's see what else. I talked to you about subjective complaints. Let me see what my little notes were. 5412. Okay. Retirement PERS. DV. Oh, this is really a wild case that I had. The client had only worked there 8 years, and unfortunately for him, there was a familial predisposition for Alzheimer's. And he's 38, and they diagnosed Alzheimer's. And he came to me, and I go, I don't know what I can do. So I start doing some research, and there was some medical research done in Washington, University of Washington. It came back and talked about sleep deprivation. It talked about change of work schedules, sleep deprivation, and how that is a contributory factor to Alzheimer's. So I read some more upon this. I thought, okay, let's try it out. So I filed Alzheimer's disease, and of course, they subpoenaed the records, and they're entitled to the familial predisposition. And the shift work this person was doing was crazy shift work. Even when he went home, he'd have flashbacks to what he would see, and all this on and on and on. So we went forward, and the employer, again, they laughing at me, what the hell are you doing? You're wasting your time. And we go forward, and the doctor comes back and happens to be a neurologist, very bright person, and the doctor was aware of the study, came back and embraced it. The employer takes his deposition, and the more they take his deposition, the stronger he gets. He says, this is a study, and I've looked since I issued my report as to supplemental studies that come back and support it. So the Alzheimer's was found to be job-related. In workers' compensation, if I can show this much has contributed, that makes it job-related. The level of impairment goes down because they get apportionment. Well, I was interested in the medical care. So he has 24-hour care. He has a big economic burden off the employer. So when the medical conditions come up, they don't have to be the traditional ones. And as our medicine expands, and as we see things in a broader sense, there's opportunities to afford a protection. And it goes back to the Industrial Revolution. We're not agrarian workers. The farmer's not going to take care of us. We have a job-related injury. The idea is that the employer has a responsibility. The employer has a responsibility. And even if it's this much causation, that's sufficient. There's a cap as to the money amount. The money amount on the case, I only got like $400,000 on the case, but the money amount on the case is de minimis versus the civil litigation. If that had been a civil litigation, we're involved in an auto accident, that had been worth about $3.5 to $4 million. Well, that's not the issue. Workers' compensation is different. So, as you leave and as you go home and you enjoy what you're doing, go back and reflect upon what you've done in your career. And if you think that there's certain days that you can't do your substantial duties, then that opens up the concept for disability retirement. You're not trying to rip off the system. If you think that the condition is job-related, then that gives you access to medical care. For you, I would like to have you read the legislative changes I'm talking about. And if you agree with it, I would like to have you start talking. I'm going to talk to Toni Atkins. She's President Pro Tem of the Senate, and she's going to be looking at this, and let her know that the impact is just really big. Yes, sir.
The firehouse attorneys were all sitting around the kitchen table at the firehouse.
Yes.
So the discussion was, is legitimate job-related injury
Right.
but you inadvertently violated department policy, which resulted in the injury,
Okay.
is workers' comp still obligated to cover it?
Yes, with this exception. If there's policy and procedure that mandates that on a three-man ladder, three-person ladder, that I always have 3 people there, and I use 2 and I injure myself, that's covered, okay? If the policy and procedure is I'm supposed to drive from point A to point B to get to where I want to do the fire, and I go from point A to point D way over here, and I'm involved in injury, maybe not, maybe not. It goes back to the ramifications. If it's just de minimis, failure to follow policy and procedure, fine. If the policy and procedure is every time there's a fire, I put a BA on and that breathing apparatus, and I don't, that's not going to impact me negatively. But there are those tools that are used by the employer to eviscerate. Now, you and I are coworkers, and I become a jerk, and I get involved in a fight with you, and you kick my butt. You kick my butt, and I injure my back. I probably won't be able to get benefits. You'll get benefits because you're protecting yourself. But if I initiate that conflict and I get injured, probably not. If I come to work and I'm loaded and I'm intoxicated and I go out and I get injured, probably not. So there are different ways that can be utilized to minimize, mitigate. But again, that's the advantage of having someone share with you the ideas. Yes, ma'am.
I was wondering, sir, if you knew about there's a presumptive bill that was put into place for respiratory for firefighters. Forgive me, I'll talk a bit louder. One thing that was not presumptive for many, many years was reactive airway disease.
Yes.
Every firefighter in here probably has an inhaler. Do you know the status of that bill? Is it?
No, I don't, but I think it's necessary. You don't have to have pneumonia to have that particular process you're speaking to. Now, if they develop pneumonia, that's going to make it work-related within the presumptive. Exactly. Unless the reactive airway disease is causing pneumonia. If it does, then that will bring it together within the presumptive. But the reactive airway disease that I see many times does not cause it. And I want that to be covered by the presumptive. Absolutely.
So it was introduced in 2016. I just wondered if it got passed, and
Not
I don't
that
think
we're
so.
up. No, it has
Yeah.
not.
It's crazy.
Well, my hearing sucks. I go to the range with my son to shoot, and sometimes I'm too busy talking to him about what we should be doing. I take the earmuffs off, so I apologize. I should make it. What was that, levity? Come on, do it again.
Said you should see an attorney.
Oh, yeah. Go after my son. Okay, any more? Yes, ma'am.
So I want to thank you for your pay-forward mentality that you are articulating here on the employment realities. However, when you sign a non-disclosure or a waiver of liabilities and you do have that workman's comp, can you still do something when you are signing off saying, I'm going into this area and I signed a non-disclosure? Do you still handle those kind of situations?
Oh, absolutely. They have no substance. They have no value. That's contrary to workers' compensation. The employer is stepping into an area that they cannot. And it's interesting what the employer will sometimes create a waiver, and that's not going to hold up. The only way that waiver is going to hold up is if the workers' compensation judge comes in and states it was a compromise and release and the worker gave up their pulmonary system. But you cannot, that has no value at all. But it's used to intimidate, it's used to dissuade people. One final area, you made me think of this. Telephone, telegraph, telefirefighter. Telephone, telegraph, telefirefighter. So what you need to do is, if you have your job-related injury, bring in and narrow down who you're going to talk to. Because unintentionally, people can misperceive what you're saying, and then they can expand and say something that's not really what you've had to say. Telephone, telegraph, telefirefighter. So what I will do, the client comes in, they have an issue, I say, and they'll say, oh, the captain wants to talk to me, the BC wants to talk to me, the DC. I said, no, You give them your attorney's card. If they want to make inquiries, have them talk to your attorney. You're always pleasant. You're always pleasant. The only person that can be an a-hole is your attorney. And you're always pleasant. You're always pleasant. And it's amazing. I got my captain bars. I got my division chief. I'm a chief. Tell me about this injury. Tell me about this injury. They're not allowed to do that. They're not allowed to do that. And again, if the investigator wants to come in and talk, you need to recognize if that case is significant, you need to get some representation. Yes, sir.
A question came up in a large administrative meeting, and we have a few people that are off ill in the organization.
Got it.
And I said, well, I'm going to give that guy a call, see how he's doing. And the HR goes, oh, no. That's illegal. You can't talk to them and see how they're doing. So what's your take on that?
I agree. And where this kind of brings in some wiggle room, I have clients and I know who the captain of the BC is, and they're really a giving, caring person, and they're not trying to create a problem. They want to drop off some food. They want to, you got issues getting your car licensed. They want to help you do that. And in situations like that, I'll weigh and measure what's happening and what the motivation of the individual is. If I have someone that's newly promoted, I'm somewhat concerned. If I've had someone that's around a long time, and if I know them and other people know them, I will then sometimes allow a little bit of latitude, But I have many times where the person is living at home, they're not able to go out and take care of the yard, they're not able to take care of this or that. And if I know who the people are that are participating and I trust them, I'll give some latitude.
The sad thing about that is, one of the great things about this profession is you know where I'm going with this. It's just with F4 and HR and so much law involved, it's tearing the fabric of what used to keep us together. It's really sad.
Yeah.
I did it anyways against advice from HR. And it was the best thing. Thank you, I appreciate it. And so our membership doesn't always know that. We're being advised by legal counsel at the highest level of the county not to do it. It's too much risk. It's horrible it's gotten to that.
What I've seen happen is many times if the person belongs to an association or union, the association or union will come in and do supplemental things to help and assist, and they're not sharing any of that information with HR. Again, thank you for your work, and I really enjoy having the opportunity to represent safety. Thank you very much.